Hello and welcome. Today I'm going to be discussing, and we're going to talk about you're being indicted, but I don't want to let it define you. So whether you're going to have a trial, a plea deal, or you're cooperating, eventually you're going to be sitting down in the courtroom with your judge, and you're going to allocute with them, which means you're going to be speaking with them, and hopefully you have been prepped with and counseled with by your attorney and possibly with someone like myself, a consultant that has impressed upon you the need to be able to speak from the heart, where you realize that there are victims that have been harmed. You're responsible for you're accepting responsibility for what you've done, and it makes this a whole lot easier. One, you really have to believe it because the probation officer that conducts the pre-sentence interview, they've got great BS detectors, and the judge definitely has great BS detectors because they talk to people all day long for years, sometimes decades. And so this should probably start, according to some federal judges, you beginning to think about this as soon as you hear possibly that you're indicted. And I realize this sounds premature because I definitely was not thinking about this when the feds showed up at my door in my practice, back in 2006. I got indicted. And I did not know any of this, to be honest with you. While I did get my medical license back, this was all foreign to me. And yet, um, if you have the counsel and someone advising you, if you're able to begin to reflect on your story of your life, and if you choose to go to trial, understanding that Department of Justice has a 98% conviction rate, but if you're able to pull details out of your life and put them down on paper, and they've been rewritten several times to where it's an eloquent reflection of your life. Some of this may actually help your attorneys should you elect to go to jail, or rather to go to trial. But I'm getting ahead of myself. To my right, you'll see my eyes go off because I have notes on another computer here. But these are all strategic decisions between you and your counsel, whether you go to trial, plea, or you cooperate with his 5K 1.1. Eventually, though, as I said, you're going to be in front of your judge. And so the judge knows very little about you. What they do know is that your attorneys are paid to say good things about you, that the Department of Justice, they want a conviction, that the prosecutor wants prison time. So the one person they know nothing about is you. And so how are you going to be able to help yourself is where, I'm going to try and address this. But we're going to start off with a reference from a quote from a federal judge, Patrick J. Schultz. And again, everything that I am sharing with you, I didn't pull out of thin air. I just learned from other federal judges is that, quoting, it's surprisingly how many otherwise competent attorneys punt at the sentencing hearing, preparing for the sentencing hearing. And this is what I'm talking about. It's not all attorneys, but this preparation is really, is the attention to detail is really not there. Um, I had someone that I was discussing that were going to engage my services, and they're either the pre-sentence interview was coming up, and they had paid the attorney through trial, but they didn't go to trial. They pled, and they wanted to engage my services, but for some reason the law firm was already paid, but they didn't want to refund some of the money to take over for them to allow the defendant or their client to engage me. And I hope them the best. But this is pretty critical point in your life. So what can you do to change the judge's mind? And this planning starts long before you get to the pre-sentence interview. Quoting another judge, federal judge Robert Scalia, don't wait to think about sentencing advocacy because 99% of federal criminal clients will be facing sentencing. Start preparing for the case for sentencing early on. We're going to continue. Your judge wants to hear from you in the courtroom. And quite frankly, probably what they want to hear from you before you even get to the pre-sentence interview. And I'll show you how that gets done. But they don't want to hear from your judge really at sentencing. They want to hear from you. And so what do they want to know? They want to believe that they want to understand. Remember, they've got great bullshit detectors. They want to understand and know that you understand that you have accepted responsibility for your actions. Several examples I'll give you at the very end where people just aren't willing to say that. But that's a core belief. They want to understand that you have remorse for the pain that you've inflicted on your victims, excuse me. But even if the charge says there's no victims, there are stakeholders, and stakeholders are people who are responsible for what's going to happen to you in your life. The first stakeholder that you're going to meet is the most important one, which is the probation officer who does the interview. The second one's the judge. And so this is very important for them. They need to understand that you've accepted responsibility. And when you don't, it's a problem. And then that you have, inflicted pain on your victims. And if you show up to court and you say, I'm sorry, and you show up in a Maserati and you owe restitution, or it was a criminal, it was um, a financial crime, it's not going to go well. They understand though the crimes don't happen in a vacuum. They want to understand what happened in your life. You're not going to be able to fudge it at that point in time if you waited. That's why it's important to go through your life and methodically, but by taking the time earlier on to kind of write this through. And it's easier to do it with those that don't enable you, with someone who's willing to work with you to just kind of write this out. What is your release plan? It sounds kind of premature. When I was in court, the judge asked me if I had anything to say. I was like, I looked at my lawyer. I said, what's he asking me that for? I said, I'm sorry. I felt like an idiot. But judges don't want to see you back in the courtroom again. And so they want a release plan. It is premature, but they want to know you have at least the beginning of a plan. What are you going to do? Depending on, how long or where you're going to prison. I mean, begin to have letters of character letters that attest to your character. Maybe somebody who has a business who's willing to hire you to sit by a telephone or to be a janitor in their business. And while nobody has a crystal ball that the business will still be there, but they'll say if they can afford to pay you a minimum or above minimum wage, they'd be more than glad, because they know you for so many years. You've got great character, you've been great in the community, and they would love to have you as an employee. That's a great letter. But they want to know that there's something that you're thinking about it. Was there other ramifications, such as losing your professional license to practice in a career you love? If it's a medical license, this is a license. You should be able to get it back, but there's going to be restrictions. A legal license, I don't know. I mean, all the certain licenses that are out there, but if it's a professional license, teaching, what have you, this is a license that you studied for, that you enjoyed, that you provided. It was a gift that you were able to share with others and help them get better or help them educate them. And so, in addition to financial that will affect your career, you enjoy bonding and helping others. When you do this, especially if you're prepared before this pre-sentence interview, which is a terribly important interview, you're able to have the probation officer is going to want a plethora of documentation from you. And if you have a medical record that will go into your personal identification information that we're briefly discussing, it's important to have all this information gathered together, spell checked, and going along with your narrative. It can be in written form, and it can also be paired with a short video. And that can be done with a smartphone if you don't have the funds to go ahead and do it with a regular video. If you have provided any sort of community service or volunteered in your community, all of these are character letters that attest to your character. There's too many individuals that are not prepared when they go into the sentencing hearing, as I was, when the judge asks if you have anything to say. And when these judges are interviewed, they're disappointed when they speak with defendants at that time. Do you feel that you're going to be prepared, or has counsel been preparing you for weeks to months regarding your narrative, personal identification, and gathering all your medical records? It's critical for your pre-sentence interview, your release plan. Your medical record, if needed, understanding that there are medications on formulary or non-formulary, what's going to be the difference? Your allocution, have you been practicing that with your attorney? Character reference letters, they need to be pretty much requested right away, and then follow up, because other than people that have other things going on in their lives, so just kind of nudge them once in a while. Your personal release plan, administrative remedy process. Sit down with your lawyer, and they should be able to go through this with you. If not, contact myself or someone like me, so that you understand that backwards and forwards. Because once you hit the 50% mark of your earned time credits with your First Step Back programming, you need to begin to start putting in requests regarding where you stand in the First Step Back. And you need to understand the administrative remedy process thoroughly. And then, the attorneys are going to be there to support you through supervised release and halfway house. If you requested, allowed a prison consultant to participate, preparing you for the pre-sentence and sentencing hearing. All of this is important because judges know, as I say, crimes don't happen in a vacuum. Your life's history, your life story, your personal narrative. This is a very important document that, you know, that goes into, it's the good, the bad, and ugly. It's all parts of your life. As part of your release plan, believe me, your judge is going to ask you. They don't want you back in your courtroom. I learned the hard way. Letters attesting your character. We went through that. If there's a job offer, that's a great letter, and that should be part of your narrative. Allocution with your judge, that takes practice. Being nervous or scared is normal, and there are many different formats that you can bring in with you that day, and your lawyer will be able to go through them with you. Defend Judges are just, as like repeating federal judge Patrick Schultz about surprising how many otherwise competent lawyers pun in sentencing hearing, referring to defendants who go into the sentencing unprepared, unrepentant, and double down on what they did. That's just crazy stuff. Examples of defendants that just were off the wall. First, we're going to go into things that you could do before the sentencing hearing, before your pre-sentence interview, rather. Things that you could have done before you even get there is begin to understand that as you write your narrative, what led you to do this, how you got involved, what your involvement was. Let's say that it was a drug crime, or rather, why you did your crime. You were on either narcotics or alcohol, or if any of these things were part of your charge, why you were whatever you were doing. If it was a financial crime, if it was medical or legal, whatever the crime was. But if you got involved on your own, you started Narcotics Anonymous, Alcoholics Anonymous, whatever it was on your own, this is all very good information that should be brought if you're in trial, to the attention of your attorney. Because that'll help you in trial. And then it'll help you again before your pre-sentence interview. It's mentioning you've already started these before your indictment or pre-sentence interview. If you started Alcoholics Anonymous, Narcotics Anonymous, gambling, sex offense type therapy. Then you want to get all this information together. Now to where I thought I was going. George Santos, this guy, he wanted 24 months, 2 years. He got 7 years plus. And as there were nowhere, was there any reference in his narrative? He never was a narrative where he acknowledged the harm he did done to his victims, system of government. Nowhere did he accept responsibility. And instead, we are to be concerned with the collateral consequences he endured. His counsel wrote on their 3-page memorandum that his offenses are serious, but they were nonviolent, did not involve narcotics or physical harm. The significant financial harm was addressed through his agreed upon restitution payment. That's crazy. He didn't have a choice. He just had to sign it. That's insulting. We're all aware that his victims go beyond what has been stated, including society, all the individuals who depended on him, voted for him, and who trusted him, and yet, yes, donated his campaigns. And counsel went into Mr. Santos's personal medical history. The court may have best received all of this through a well-written narrative, which we'll talk about, or current treating physicians' medical records. I didn't see any of that. And this is the video, but this is their memorandum. It's right here on my website. Going into another gentleman, this was just Mashinsky. This was a crypto felon. He went in and the DOJ wanted 12 years, 20 years. He got 12. He wanted 2 years. Mashinsky wanted 2. DOJ wanted 20. He got 12. And he really, I don't think he prepared at all for a personal narrative, didn't prepare to allocate with the judge. He may be considering a pardon because it's crypto in the age of Trump. But, we don't know. There's no guarantee he's going to get a pardon. And again, hear his memorandum, but nowhere in there is counsel showing us that he wrote anything regarding what he did was, acknowledge. I mean, he did acknowledge. I take it back. He did acknowledge that he did acknowledge responsibility for what he did. I'm getting lost in the words here, but I don't think. Well, apparently, it was not enough to change the judge's mind. And so, lastly, I got 2 in here for him. We go to opening statement started for Sean Diddy Combs. And all I can say here is that I hope he's got excellent attorneys. He got the best money he can buy, and his attorneys are actually the same as Sam Bankman-Fried. His lawyers are the best, and I hope that he will listen to them. I don't know that he'll get off scot-free. In fact, I doubt it. But he definitely has the best of the best. And so if I'm to take away anything from this YouTube, It's that I hope don't be defined by your indictment. If looking at prison time, it's temporary. Accept responsibility, have remorse for the victims harmed. You're never coming back to the courtroom, and you're making amends to the victims of the community. And being heartfelt, there's always a tomorrow. I appreciate you taking the time to listen, and I hope you all have a safe, good day.